Dictation number SV200 TN009. Get ready. Start. Sir, I would like at this stage of the debate to make a few comments on the motion which has been moved by my honorable friend Professor Shah. I agree that he has raised an important matter for consideration of the House. In principle, I agree with him that strong deterrent action is required in regard to antisocial conduct of the kind to which his motion relates. But speaking on behalf of the government, I regret that I am not in a position to accept the motion as it stands, neither the form in which the bill has been formulated nor the precise proposals which are embodied in it. I think the matter requires fuller consideration in the light of the whole context of law and administration bearing upon these problems. The House is aware that it is our intention to place before the House at a very early date a bill for a comprehensive amendment of the Indian Income Tax Act based principally upon the recommendations which have been made by the Income Tax Investigation Commission. I hope it will be possible for me to introduce that bill before the end of the session. In that bill, this particular problem which Professor Shah has raised is one for which proposals are to be included in the draft bill is that in the case of person who makes false statements in regard to their income tax returns, their position should be exactly the same as their who fabricate evidence in a judicial proceeding. The position at present under the Income Tax Act is that a person who makes a false statement in connection with his income tax returns is liable to be sentenced to simple imprisonment for a maximum period of 6 months with fine. The provision which we are going to put into the bill, which will shortly be placed before the House, is that a person who makes a false statement should be dealt with under the provisions of the Indian Penal Code, which deal with fabrication of evidence in a judicial proceeding. Therefore, if that provision is accepted by the House, the penalty involved would be increased from 6 months simple imprisonment to 7 years imprisonment of either description. It seems to me, therefore, that bill will provide the House with ample opportunity of examining this particular question, not in isolation, but as I said, in the whole context of income tax law and practice. I suggest, therefore, respectfully to the House that it should reject this motion at present and wait for the opportunity which this bill would give to the House. There are other recommendations which have been made by the Income Tax Investigation Commission. The line that they have generally taken in regard to this matter is that it is not so much penalty in the form of imprisonment and fine which will really act as a deterrent. What is necessary is to bring social odium to bear upon people who commit antisocial offences of this kind, and one of the suggestions that have been made is that the names of tax evaders should be published. Another is that they should be disqualified from appointments to posts of trust which it is in government's power to confer. It is open to the House also to consider whether they should not be disqualified from standing for elections. These forms of social censure would probably act as a stronger deterrent. I may say this is a matter which has engaged the attention of the government in recent months. A few months ago, under instructions from the Prime Minister, we issued directives to various departments of government that in the matter of giving contracts and licenses for export and import, we must insist that the applicants must produce a clean income tax record. We have been acting on that. Of course, the introduction of open general license to some extent has prevented us from making the fullest use of it. So the matter is already engaging the attention of the government on lines somewhat similar to those suggested by Professor Shah, but in a manner which is more in accordance with the practical requirements of the situation. The bill covers not only the question of tax evasion, it involves also the question of black marketing. Offences of that kind are at present dealt with under the Essential Supplies Temporary Powers Act. The penalty provided in the Act is that those who are guilty of offences under the Act might either be sentenced to imprisonment of either description for a period of 3 years, or might be fined, or the property involved might be forfeited to government. I personally think that these penalties are sufficiently severe, particularly the provision in regard to forfeiture of property. I would like to say in connection with the operation of the Act that the real problem is not to make suitable legislative provision. The really important thing is to provide for satisfactory administration of such legislative enactments as we have on the subject. Those who have had any experience of the practical administration of anti-corruption laws will realize that the real difficulty is to produce sufficient evidence to have the guilt brought home to the party concerned. Therefore, I am inclined to think that if the House is going to deal seriously with this matter, it must direct its attention not so much to fresh legislation as to the question of implementing existing legislative provision in a more satisfactory and effective manner. The really important point to my mind is to stiffen the administrative organization. My suggestion therefore to the House is that it should reject this motion at present and should avail itself of the opportunity of having the whole question re-examined in the light of the above facts when I bring forward a bill before the House before the end of this session. Stop.